देखो अभी, हाँ हाँ देखो, बताओ अभी, देखो ना, लिखा है ना मराठी में। हाँ किया ना पीपीटी, हाँ देखो आपको दिख रहा है, क्लियर दिख रहा है, देखो क्लियर दिख रहा है क्या?
So, prior to coming to the trade related aspects of intellectual property rights, that is TRIPS, we also have to look into the historical perspective, that is the growth development of intellectual property right. But let us also understand the notion of property. So it is a property. So what is property? That is property which is allowing the owner to completely benefit from his or her product, his or her creativity, which was initially her idea or his idea, that is developed and that is crystallized, entitling that person to prevent others from using, dealing, tampering with his or her product without prior permission from him or her, and he or she can in fact legally sue them and force them to stop and compensate for any damages. Let us look into the evolution of intellectual property rights. So, intellectual property rights initially started in North Italy during the Renaissance era. So, Renaissance era is a new era in the European history where we see paintings, where we see architecture, where we see designs. It is a whole era of revolution where artistic creativity is evolving. And 1474 Venice is issuing a law regulating patent protection, that is granting exclusive right to the owner. Copyright law, it is dating back to 1440 AD when Johannes Gutenberg invented the printing press with replaceable, movable, wooden or metal letters. And in 19th century, number of countries have felt the necessity of the rules or the regulations or the laws for regulating intellectual property right. Now, the two significant conventions constituting the basis of IPR worldwide, they are signed as Paris Convention for the Protection of Industrial Property 1883, Berne Convention for the Protection of Literary Artistic Work 1886. Protection of IPR allows the innovator to, or the brand owner or patent holder or copyright holder to benefit from his or her work, labor, investment, which does not mean monopoly of the intellect. And these rights are set out in the International Declaration of Human Rights, which provide for the rights to the benefit from the protection of moral and physical interest resulting from the right holder's work, literal or artistic product. Now, trademark, geographical indication, industrial design, patent and a trade name. So what is a trademark? It is a sign that individualizes the goods or services of a given enterprises, distinguishes them from those of competitors, and it is to fall under the law of protection. A trademark must be distinctive, not deceptive, disparaging, illegal or immoral. For example, you may see some of the beauty products or some of the face packs or some of the moisturizers which claim that their product is much better than the product of another company. So this kind of advertisement should not be allowed, but it has to be distinctive, maybe a different color altogether for that particular way, or it may be a mark in the sense it may be a collective mark, or it may be a symbol of a particular unit or a particular a group of companies for that particular matter. Geographical indication, basically it is a notice stating that the given product is originating in a geographical region or a particular area, or it may be handcrafted, or there may be a process of making having the appellation of origin. So Rockefeller cheese which originates in the region of France, or it may be the coffee beans which are coming from the various parts of the world, or from the Indian territory, or you have the tea, that is Darjeeling tea, having the first geographical indication in the country, or coffee beans from the Nilgiri region. Because of that particular moisture, that particular climate, the beans, the fragrance or the aroma, it is having its specific component. Or you have the Pashmina shawls from Kashmir, you have the Chamba rumals from the state of Jammu, and the chikus from the region of Dahanu, or strawberries from the region of the Mahabaleshwar, or mangoes, Alfonso mangoes from the region of Maharashtra, that is Ratnagiri, Konkan belt, and the chilies which belong to the Manipur region, which have which are very very famous for being too small, but they are spicy, they are very hot. Or we have the Govind Bhog rice which belongs to the region of West Bengal, but it is a sticky rice for that particular matter. Now international GIs, if you are looking into, it is for wine, it is for aromatic fragrances, it is for spirit, it is for Idaho potatoes for that particular matter, we may say, or it is for various other products also. That is the watch from Scotland, they have a mark into it, or cheese, variety of cheese which comes from Italy and which comes from France. Spirit and aromatic fragrances, that is, you may call them to be as certain sprays which we take over, or then perfumes for that particular matter. Then we have industrial design, which may have some aesthetics, some beauty. Ergonomics, that means the shape or the design, it is made in such a manner that it is going to suit us, and it is consisting either of three-dimensional product, or it can be the creation of the product shape or two-dimensional one. It can be graphics, it can be patterns, and it can be colors. Now patent is exclusive right granted by law to inventor or to assignee, or to prevent others from commercially benefiting from his or her patented invention without permission for a limited period of time in exchange for detailed public disclosure of patented invention. Now a trade name, it is a name of a particular business or a brand, and it is uniquely distinguishing one business from other. Trade secret, that is a secret formula, for example Coke, for example the other drink which you, other beverages or the drinks which you may have. So there are certain recipes which are coming traditionally and which are being protected, or it may be a other kind of a trade secret which is trying to maintain the confidentiality. Integrated circuit, that is a product in its final form or intermediate form, in which the elements, or at least one of which is active element, and whereby there are number of interconnections which are integrally formed in and on a piece of material which is intended to perform electronic function. What is a copyright? It is a form of IPR concerned with protecting the work of human intellect. The domain of copyright, it is literary, it is artistic work. It might be in writing, it can be in music, it can be fine work, art. And certain rights, they are the neighboring rights, that are the rights in certain respect resembling the copyright. Now the purpose of related right, it is to protect the legal interest of certain individual, namely performer, producer, broadcaster, and to help them to deliver their messages to the public. Now, what is the concept of property? Property, it can be qualified, it can be qualified property. That means it is the man having property over wild animals which have been domesticated. And corporeal property, it is property which is perceptible to the senses, such as land, house, goods, merchandise. Incorporeal property, that is legal right, that is in choose in action, easement, etc. And there are different definitions of property. So section 2C of the Benami Transaction Prohibition Act defines property as property meaning of any kind, that is movable, immovable, tangible, intangible, and including any right or interest in such property. 211 of the Sale of Goods Act 1930 defines property as meaning the general property in the goods and not merely special property. There are certain theories which are jurisprudential in nature, and they are discussing the concept of property. So these theories, they are the historical theory of property, the labor theory of property, psychological theory of property, functional theory, and philosophical theory of property. That is, property is a mean to ethical end, and property is not an end in itself. So what is property over here? It is the ownership. So let us look into historical perspective. It has been written and evolved by Henry Maine, a historian and a philosopher, and according to him, property has grown from the notion of the concept of joint property, where collective property was owned by members who were staying in large societies, and chiefly they were the patriarchal society. So Roscoe Pound in his theory is pointing out the fact that the earliest form of property, it is in the nature of group property, and later on when families have partitioned, the existence of individual property is coming into existence. Then we have the labor theory by Spencer, and it is known as the positive theory. The underlying principle over here, it is the labor, that is the hard work which has been put forward by the individuals. That is the foundation of property. And the theory is stating that a thing in the property of a person who produces it or brings it into existence. The chief supporter of this theory is Spencer, who developed the theory on the principle of equal freedom. And he has stated that property is a result of individual labor. Therefore, no person has a moral right to property which he has not acquired by his personal efforts. Psychological theory, it is psychological. You believe that something belongs to you, and it is on account of acquisitive instinct of human beings. Hello. 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 So, according to Bentham, property is altogether conception of mind. And it is nothing more than exception to derive certain advantages from the concept according to one's capacity. Hello? Hello? Yes? Chandar, I'll give you a call. I'm in class just now.
No, man, no worries, man.
I'll give you a call in some. Okay?
Yes.
So Roscoe Pound is supporting Bentham in his school of thought, and he's observing that is the sole basis for the notion or for the conception of property is the acquisitive instinct. That is, we acquire something, we feel happy when we have something, when we possess something. So each and every individual is desiring to have something which is belonging to him. It is in his possession. And that is the reason when something is created by a person by himself, it is his acquisition and his happiness to acquire such property. So that is the mind, that is the psychological theory put forth by Bentham. Now functional theory, it is sociological theory of property. It is property is situated in the society and has to be used in the society, and it is for the purpose of society, and no one can be allowed to have unrestricted use of property to the detriment of others. That means to harm others. Property is not for that purpose, but it is for utility. It is for forwarding benefit to the other members of the community, for the welfare of the community. So property is a social fact, and it is the character of social facts to alter. Property has assumed various aspects, and it is capable of changing further with the changing norms of society. So according to him, property is created when there is the origin of law, when there is the origin of state, and at that time the notion of property is also coming into existence. So property, it is the creation of the state. So intellectual property is a term referring to indicating different type of creation, and property has made abundantly clear that it is not only tangible things like house, car, furniture, currency, but it is intangible assets also. Today property is in cryptocurrency. Those are the notes which are in plastic form, or the plastic currency, but there also ownership is being taken over by the people purchasing cryptocurrency. So there are many forms of intangible property which is known as intellectual property, which is being recognized by law and which is being granted protection. So we are not referring to this part, we have already discussed. Now there are nations which are trying to protect IPR, and it is new innovation in IPR domain leading to human progress, leading to advancement. We all are interdependent, so we all require developments, we all require innovation, we all require progress, we all require communication, divergence, and innovation encourages safe spending on another innovations. So IP is to be cared, it is to be protected, and it has to be contributed for achieving economic and social development. Now, intangible nature of IP presents difficulties when it is compared to traditional goods like land or goods. They can be protected, they can be saved, they can be wired, but traditional property, IP is indivisible, since an unlimited of people can consume IP goods without it being depleted. So investment in intellectual goods suffer from the problems of appropriation. That is, a landowner can surround his land with a fence, he can have armed guards to protect, but a producer of information or literature can do very little to stop their first buyer from replacing it or selling it at a lower price. So balancing rights, they have to be strong enough laws for encouraging the creation of intellectual goods, and goods should be used, but IP has to be protected, and this is the primary focus of intellectual property right. Now let us look into the copyright law, the historical perspective. So it is the Statute of Monopoly 1642, the British Statute of Anne 1710. They are seen as the origin of patent law and copyright respectively, firmly establishing the concept of intellectual property. Literary property was the term predominantly used in British legal debate of 1760-1770, over to the extent which authors and publishers to work also had rights deriving from the common law of property. Miller versus Tyler is the case in 1769, Hinton versus Donaldson 1773, and Donaldson versus Beckett in 1774. Now the first time the term IP is coined, it is published in Monthly Review of 1769 using this particular phrase of intellectual property, and the clear example of modern usage goes back as 1808, and the German notion over here of intellectual property, it has been taken over by legislative power. The legislation is granting this kind of protection by suits gestium agentimus to the Confederation. Then we have administrative secretariat, that is established by Paris Convention 1883, Berne Convention 1886, which is merging in 1893, and it is called as the International Bureau for Protection of Intellectual Property, and it is in the year 1893. Subsequently, this organization, it is relocated in Geneva in 1960 and succeeded in 1967 with the establishment of WIPO, that is World Intellectual Property Organization, by treaty and by United Nations agency. According to legal scholar Mark Lemley, it was only at this point that the term really began to be used in US, which was not party to the Berne Convention and which did not want the IP regime, but it began to think of IP and saving of their intellectual property by the passing of the Bayh-Dole Act of 1980. Now relating to patents, it is Queen Elizabeth in 1508 and 1603 granting the monopoly privileges to the inventors, and approximately after 200 years of her reign, a patent representation was there, that is a legal right which has been obtained by the inventor, providing for exclusive control over the production and sale of mechanical and scientific invention. That is the evolution of patent from the royal prerogative to the common law doctrine. Now the term can be found used in October 1845, Manchester Circuit Court ruling in the patent case Dovell et al. Versus Brown, in which Justice Charles L. Woodbury wrote, "Only in this way can we protect intellectual property, that is the labors of mind, production, interest, as much as the man's own wheat he cultivates should be protected, or the flocks which he rears must be protected." Now, whether discovery is a patent or discovery is an intellectual property, one can deny, because discovery is something which is already there existing. It is discovered. For example, the galaxy of star. So Newton could discover this because he had the instrument where he could read into the stars, and he could see, he could discover there is a galaxy of star. But the invention through which he discovered that those stars were there, that can be called as intellectual property, and definitely it has been registered also with intellectual property. So when we see stars from a distance, we call that instrument to be as yes, we call it to be as the telescope, and definitely when we say it is a telescope, it is the discovery which had been which was done over by Galileo, by Newton for that particular matter, and Galileo, and therefore section 1 of the French law of 1791 says that all new discoveries are the property of the author, to assure that the inventor of the property and temporary enjoyment of his discovery, there shall be delivered to him a patent for 5, 10 or 15 years. And this particular author has mentioned propriete intellectual in his Droit civil des authors Artis ad inventor, which is published in 1846. So if we are looking into the history, then it can be traced further back to the Jewish law, which is including several considerations affecting which are similar of that of modern intellectual property right, though the notion of intellectual creation as property is not there existing, but nevertheless the principle of unfair encroachment was used to justify limited term as publisher but not author in the copyright of 16th century. Now the Greek state of Siberius offered 1 year's patent to all who should discover any new refinement in the luxury. And Jean Frederick Morin, the global intellectual property regime is in the midst of paradigm shift, and in 2000 the global IP regime has used to be dominated by high standard of protection, characteristics of IP law from Europe, US, with the vision that uniform application of these standards all over the nations and to several fields with little consideration over social, cultural, environmental values of or the national level of economic development. Now, the development agenda adopted in WIPO in 2007, there are a set of 45 recommendations to adjust WIPO activities to the specific needs of developing country. The aim to reduce distortions, especially on the issues such as patients' access to medicine, internet users, their access to information, farmers' access to seeds, programmers' access to the source or the data codes, or students' access to the scientific articles. This is a paradigm shift, and it has not yet manifested in itself in concrete legal reform at the international level. Now, the basic treaty which has come into existence for having a uniform standard practice and the laws regulating intellectual property, that is the trade related aspects of intellectual property right, we call them to be TRIPS, and it is agreement requiring members of World Trade Organization to set minimum standards of legal protection, having the object that is one fits all protection of IP, and it is viewed with controversies regarding differences in the development level of countries. Despite the controversy, the agreement has extensively incorporated IP rights into the global trading system for the first time in 1995 and has prevailed as the most comprehensive agreement reaching over the world. Okay. Now let us look into TRIPS. So TRIPS, I told you, it is the negotiations which are commencing from 1986 to 1993 They are the part of Uruguay round of multilateral trade negotiations of GATT, and it is coming into force from 1st Jan 1995 with the establishment of World Trade Organization. Now, this treaty, it is providing for minimum norms, standards in respect of the specific categories of intellectual property, that is copyright related rights, trademark, geographical indication, industrial design, patent, layout designs of integrated circuits, and the protection of undisclosed information. Now, let us look at Article 2. It is obligating the compliance with Article 1 to 12 and Article 19 of the Paris Convention, and it is for protection of IP, providing that nothing in the given agreement shall derogate from existing obligations which are prescribed in the Paris Convention. So even TRIPS, it is continuation of Berne and Paris Convention, and the same have to be followed for protecting the industrial designs and for protecting the copyright. Now we have the International Convention for Protection of Performer, Producers, Phonograms Treaty. We have the Broadcasting Organizations, that is the Rome Convention of 1961. Hello sir, hello. So you have the Treaty on Intellectual Property for Integrated Circuits 1989, the Berne Convention for Protection of Literary and Artistic Work 1971. So what is the basic notion or the basic protection or the basic postulates of TRIPS agreement? It is national treatment, where each member country is required to provide national of other member countries' treatment no less favorable than it accords to its own nationals. So if a country is protecting its goods, the similar kind of protection is to be provided for industrial property or industrial rights to nation B also, and subject to exceptions and protection provided in the Paris Convention, the Rome Convention, Berne Convention, and we have the IPCI Treaty. Now copyright, it is protection which is protecting the original. It is creative expression of the idea, begins automatically from the date of creation, usually without being subject to any formalities as being specified under Article 5.2 of the Berne Convention. The enjoyment and exercise of these rights shall not be subject to any formality. And the term, expression, system, method, it is there, and it has been stated by Lindley Justice in Holinker versus Trustwell 1894 to Chapter 420. Now Article 9.1 of the TRIPS agreement stipulates that members shall comply with Article 1 to 21 of the Berne Convention, with the exception of Article 6 bis 24 as it is provided in the exception. Then this particular droit et la patronite and droit et you respect the lover, it is recognized under section 57 of Indian Copyright Act of 1957 and survives even after the assignment of copyright, either wholly or partially, with the exception to the computer programs. The mean or the mechanisms of redress that are governed by the legislation of the country where protection is claimed, that is the moral rights, are the right to decide whether to publish, not to publish the work, that is the right to publication, droit de divulgation, the right to claim authorship of a published exhibited work, that is droit et la paternité, the right of paternity, and the right to prevent alteration and other actions that may damage the author's honor or reputation, that is droit et respect de l'auteur, the right of integrity. Berne Convention, Article 8, that is exclusive right of making, authorizing, granting authors of artistic literary work under the convention, including the right of translation, right of reproduction in any manner. Article 9, including sound, visual recording, the right to authorize the performance, the dramatico-musical works, public performances, means to process, public communication of these performances, and right to translation. Article 11, right to broadcast, to communicate to the public by wire, rebroadcasting or loudspeaker or any other similar instrument, the broadcast of the work. Article 11, the right of public recitation by means or process, public communication to the recitation of their work, and right of translation. Article 11 bis, the right to make adaptation, arrangement, alterations of their work. Article 12, the right to make cinematographic adaptations, reproduction of their work, performances, communication by wire of these adaptations or reproduction. So, copyright, Article 14, it is the copyright of work first made, published in the country where the author is belonging to, and the date of publication, and a national of a country who is a member of Berne Convention for protecting the literary artistic work or universal copyright protection or of WTO are protected in India as if it is Indian work based under Section 40 of the Indian Copyright Act of 1957, read with International Copyright Order of 1999. So, accordingly, all provisions of Indian Copyright Act, they will apply as if they are Indian work, and copyright is a statutory creation and registration is not mandatory, but it is always advisable that the creator must register his work in order to avoid infringement. And what is it? It is consisting of a bundle of rights which can be assigned, which can be transferred, which can be licensed either as a whole or separately. Now, assignment is in essence a transfer of ownership, even if it is partial. On the other hand, a license is a permission to do something but for the license it would be as infringement. So this is all about copyright and computer databases, Berne Convention, Rome Convention. So trademark, the provisions relating to trademark, it is in Article 15(1) of the TRIPS agreement, establishing that any sign or any combination of sign capable of distinguishing the goods or services of one undertaking from another shall be capable of constituting a trademark, that is, they are eligible for registration. And 15(1) of the TRIPS agreement limits the right of the member to determine the condition for filing and registration of trademark under their domestic legislations in accordance to Article 6(1) of Paris Convention, only as it is relating to the distinctiveness requirements which are there under Article 15(1). In India, it is defined under Section 2Z of the Trademarks Act of 1999, meaning services of any description, including the provisions of services in connection with the business of any industrial or commercial matter. And there is a non-exhaustive list of services. It can be sign, it can be word including personal name, letter, numeral, figurative element, combination of color, combination of signs which are eligible for registration. And it is mark capable of being represented graphically, capable of distinguishing goods or services of one person from those of the other person, also including the shape of goods, their packaging, and the combination of colors. So, TRIPS Article 15(2), members are not prevented from denying registration of trademark on the grounds that they are not derogating from the Paris Convention. So, trademark shall not be refused registration for the sole reason that it differs from the mark protected in the country of origin with respect to the elements that they do not affect its identity. So, Article 16(4), it is telling you about the nature of goods or services to which trademark applies, and it shall in no case form an obstacle to the registration. So, Article 6, Quinins B, the Paris Convention provides that trademark may neither be denied registration nor invalidated except where they are of such a nature. Now, the agreements are stipulating that owner of a registered trademark shall have exclusive right to prevent third parties from using these signs in goods or services in the course without the owner's consent which are identical or similar to a registered trademark for goods or services which use would result in likelihood or confusion. So, we have the European Council, they too provide for protection of trademark, geographical indication for agricultural product and foodstuff. And compulsory non-voluntary licenses do not provide an exception to the rights of right holder of a trademark, that is Article 21 of the TRIPS agreement. So, under 5(1) of Paris Convention, registered mark is compulsory and registration is mandatory. Under Article 19, the TRIPS agreement specifies a period of 3 years under Article 5(c)(1) of the Paris Convention. Under Article 47 of the Indian Trademarks Act of 1999, it prescribes a period of 5 years subject to qualifications. So, Section 11(3), it is providing for trademark cannot be registered and in India liable to be prevented under the law, but 29(1) provides register trademark if it is infringed, then the person whose trademark is being infringed, they can have recourse to legal action, and so the registration of the trademark, it gives registered proprietor to the exclusive right to use his trademark in respect of goods and services and obtain a relief in case of infringement. So these are identical deceptive trademarks. You can see a camel, over here a Droid, a Pringles for that particular matter, Glucon-D, it is written in a different manner, Glucon-D. Then Nestle, it is written as Nasty. The Home Lives, over here again you can see the difference which can be seen. Then Cadbury Dairy Milk, it's written very badly where you cannot read it as dairy milk. Oreo, it has come up as Go-Go Biscuits. Then Pitchers, it is Palms. And even toothpaste, if you see, there are many differences you may note down. Guitar, the product, you can see the differences in the making, but something, it looks quite identical also, copy of it. And this is a measurement machine. Paytm, it came as PayPal, and that also is not being recognized. These are the designs which you can see, that is prior to registering, the specifications have to be clearly given, and then only drawings and specification it can be registered. So this is regarding the protection of intellectual property rights, students. Let us continue further. So in future, if you are wanting to have me conducting some more lecture into intellectual property rights, so please inform, and then we can continue. And today with this I will take your note and I will wind up this class. So I thank all the students for attending the class, and I also apologize to the students due to some reasons the continuity was lost, but I have tried to cover the same. But nevertheless, in future also we will continue with these classes, and maybe 1 or 2 lectures I can conduct more, but IPR we cannot conduct too exhaustively because it's all theoretical in nature. So let us continue in the next class. With this, I forward a thank note to all the students. Thank you, students, for joining the class.